this discussion on the screening regulation. And actually, I salute the persons online. We have much more persons online than in the room. We welcome this morning Fabian Lutz, who is an official working in DG Home at the Commission, and is now in charge of the screening regulation. You may know that in the Commission, most of the time, each legal instrument is attributed to one official who really has on his file this one instrument regarding all steps, discussions with member states, representation in council, representation and discussion with the European Parliament, trilogues, and so on. Before entering into the discussion, let me just say that Fabian Lutz has, in the Commission, worked on two main subjects. He was recently working on legal migration, and he has, and I think that this is his main achievement in the past, being in charge of the Return Directive. And actually, one can say that he's really the father of the Return Directive. He drafted it, so he really had to start from scratch on paper and to draft the proposal for a directive for the Commission. Then he had, of course, to discuss it with the Parliament and the Council, and to participate into the discussions between the co-legislators. And actually, contrary to what people may think, in the co-decision, which gives the idea that it is between two actors, Parliament and Council, you have a third actor, and this is why the discussions are called trilogues, and the third actor is the Commission. And very often the Commission is acting as a kind of broker between Council and Parliament, trying to find the compromises and very often to draft compromises, because it's difficult for member states and members of the Parliament to really find a compromise acceptable for everybody. If you leave one member state representative draft one provision, he will very often come up with a cut and paste of its own legislation, and this, of course, will not float. So, good or bad, that's another debate that we will have in next session. Fabian Lutz is the father of the Return Directive. One can say that without him, there would be no Return Directive at EU level. I know his talent for diplomacy and negotiations, and he was really the artist trying to find a way between Parliament and Council. But he's now working on the new pact, and more precisely, as I said, on the screening regulation. And we are going to have a discussion about that. I have a number of questions for Fabian, but maybe we should start with a first statement about what is the screening regulation, what is the content of that regulation, and then maybe afterwards the goals, the objectives of that regulation. You don't need, Fabian, to make a long speech. This is a discussion, so the aim is also to have an exchange with the participants. So I leave you the floor.
Well, thanks, Philippe, for this friendly introduction. And I can only confirm what he said, that indeed, I mean, whenever it comes, I think, to political negotiation in general, it's not only the substance which counts, but it's also very important that there is someone who is taking the pen and who is trying to find formulations which are concise and clear and puts it down on paper. Because only that way political compromises can then substantiate into legal texts. We should never forget that. So wherever you will work later on in your life, I mean, really, you can make an important contribution not only by doing substantive negotiations, but simply to try to frame things intelligently into a legal text and also to strive for legal clarity. Because in the end, I mean, I'm a lawyer, law should be something like mathematics, where 1 and 2 makes 3. And not 1 and 2 may, under certain presumption and with the objective of something, be tantamount to 3. So believe me, I'm myself suffering sometimes when I have a look of these proposals which the Commission is now proposing. And I think last week you had a good example also of the AMMR proposal, where it's extremely complicated formulations. And my experience is also in the practical life, I've been working for 20 years now in this field of migration for the European Commission, that the more simple and the more clear a proposal is from the outset, the higher the likelihood that there will be an adoption. And when a proposal is already very complicated in the beginning, then the negotiations will in the same way be very, very complicated, and there's always a high risk that negotiations may fail. So far for this preliminary remark. Let us focus on screening now. You already heard about the pact last week. I need not repeat the pact, which is in fact not a pact, but it's a set of proposals by the European Commission. So normally for a pact, you need always 2 partners. And the pact, I mean, it's a way of framing this proposed new migration and asylum governance system proposed by the Commission last September, consists of a number of proposals, amongst which there is this screening regulation. The screening regulation was proposed as a part of the Schengen acquis. So it's not a part of the asylum acquis, not a part of the return acquis. It was proposed as a part of the Schengen acquis, directly related to the Schengen Borders Code. Schengen Borders Code, probably this also rings a bell with you. Schengen Borders Code is this key instrument of Schengen law, which has a twofold objective. On the one hand, abolishment of internal border control, so no more internal border control, at least in an ideal world, between member states, and a common discipline at the external borders. What the Schengen Borders Code currently foresees is that when someone is crossing the external border, this shall only happen at border crossing points. And when you come to a border crossing point, which can be a land border or a sea border at a port or an air border at an international airport, you must show your papers, you must demonstrate that you fulfill the entry conditions. Then you are checked against the IT bases, which we have, the SIS, the VIS, and the other databases. So your identity is checked. It's checked that you are not a terrorist, that there is no arrest warrant against you. You find this information in the Schengen information system, for instance. And in times of a health crisis, there may also be checks regarding your health status, the vaccination certificate. So this is this threefold objective for the external border control, which I have in the Schengen Borders Code. Check of the identity, check that you don't pose a security risk, and check that there is no health risk. This applies both for EU citizens and for third country nationals. What we don't have currently in the Schengen Borders Code, and that's now why we propose this screening regulation. When it comes to crossing the borders outside the border crossing points, so irregular entry, we only have currently Article 13 of the Schengen Borders Code called Border Surveillance, which says that member states shall prevent irregular entry. Member states are obliged to make sure that migrants and persons only enter through border crossing points. So there is a general duty of member states, and also in the support of Frontex, to make sure that there is no irregular crossing of the external borders, be it by legal or by irregular migrants. What happens if someone is nevertheless crossing irregularly the border? This is somehow left open. There is no rule that proper border checks need to be carried out, because border checks can only be carried out at border crossing points currently. So for instance, when people are searched and rescued in the Mediterranean and then brought to a Greek island, they are not undergoing a border check currently, because border checks are only done at international border crossing points, and there you have the checks against all the databases. But for searched and rescued people who are brought to some port, and then which is not necessarily a border crossing point, there is no systematic obligation for doing all these checks prescribed in the Schengen Borders Code. The same also applies to irregular migrants coming through the land border or swimming, let's say, the Turkish-Greek border. There is the Evros River. When you swim through the Evros River and you are apprehended by the Greek police, you're treated as an irregular migrant, and you're passed on. Either you make then an asylum application and then you pass to the asylum authorities, or you don't make an application for asylum, then you're treated as irregular migrant, and then you go into the Greek return procedures. But we don't have, for the moment, an obligation to do this security check, identity check, and health check on these migrants who enter outside the border crossing points. And this, indeed, was one of the two main reasons for having this screening proposal. The screening proposal has two main reasons. On the one hand, to complement the Schengen Borders Code and to really prescribe a common discipline, saying all member states, Greece, Italy, Malta, but also Finland and Sweden, because they also have external borders, namely the airports. Whenever migrants arrive, be it regular or irregular migrants, be it outside border crossing points, you are always obliged to carry out these checks, the identity check, the security check, and the health check, in order to make sure that at least Europe knows who has entered the territory. So this is the first important component. Some of you may ask, why hasn't the Commission simply proposed then a change to the Schengen Borders Code? We could have added an Article 13a of the Schengen Borders Code, border surveillance, and prescribed this obligation. This is a very valid point. Indeed, this could have been done. But there is also a second element in the screening proposal which explains more why we have put it in the context of the pact as a separate proposal. Namely, then, that member states, and that's in Article 4 of the screening proposal, shall be obliged to keep the irregular migrants and the searched and rescued persons who have entered outside the border crossing point in certain facilities at the external border, close to the external borders, for a number of days needed to carry out these checks. So to say, a common discipline on member states to make sure that these people, these migrants don't abscond, don't disappear, don't then move upwards to Germany and Sweden, but to keep them at the external border, to carry out these 3 checks which are prescribed by the screening proposal, and afterwards to make sure that they are passed on to the right authorities. So either the asylum authorities or return authorities, or when it's clear that they don't fulfill entry requirements and they have not applied for asylum, possibly also a refusal of entry, that they are brought to the border crossing points and directly refused entry. This goes hand in hand with the establishment of sort of a screening form, a debriefing form, where the screening authorities, so those who carry out the screening, in a sort of fact-finding exercise, note the essential findings which they could establish about the person. So what is the identity, were there hits in the IT system, was there a public order risk which was identified? Also, there will be systematically a vulnerability assessment, so could any vulnerability be found? And also health check, is there any risk to health? All this should be put together in this sort of fact-finding sheet and passed on to the other authorities in what we call in the pact, in a seamless procedure. So the idea is that there is the migrant who is apprehended and undergoes screening has no chance to abscond and disappear before the asylum procedure is launched. No, there should be this seamless procedure, probably also maybe even in the same location physically, that first you have the screening and afterwards you will have the asylum border procedure and possibly also a return border procedure under our new proposals, or if the persons don't fall under the scope of the asylum border procedure. You already had that, Philip? Asylum border procedure under the pact?
Yes, we already had that.
Yeah, because certain categories, those we have a low likelihood of getting international protection, they will be immediately channeled into the asylum border procedure at the external border, and those who have a high chance of obtaining asylum, they will go into the regular asylum procedures within the territory.
Actually, it's the course of this afternoon.
Ah, okay, so I'm preparing you for this afternoon already. So this is the main idea of the screening, so to say. Twofold: on the one hand, a systematic obligation on member states to always, on each person entering the territory, to conduct these checks, which are normally carried out only at border crossing points. And the others is to make sure that the people don't disappear, that they are in special facilities, that if necessary also detention is applied during the first 3 or 5 days during which the screening should take place, and then to pass on in a seamless procedure either to the asylum colleagues or the return colleagues or the colleagues in charge of refusing entry. And what is very important, and then I give the floor back to you after this introductory statement, screening is not a procedure. It's not a separate procedure. Screening, it's a frequent misunderstanding. I myself had this misunderstanding when I first heard about the idea. It is sort of it's an extended border check. There are no binding results. This debriefing form, the screening form, which is produced at the end of screening, has no binding legal value. And therefore, there is also no right to appeal it immediately. It's just a sort of a preparatory evidence collection exercise, as the border guards also do it already now at our external border, at the border crossing point, on the basis of which then the asylum or the return authorities will take action. And everything which was established during the screening, identity, vulnerability, age, country of origin, all these things can then be, if they are not true, challenged with legal remedies in the subsequent asylum or return or refusal of entry procedure. Because that was the main point of criticism immediately when the when the screening proposal came out was, you provide sort of a legal vacuum, findings, a new procedure without legal remedies. This is certainly not the case. As I said, we need to look at it as a preliminary fact-finding exercise.
Yes, that's indeed, I think, a very important point to understand what is the screening. So it leads either to an asylum procedure, either to a return procedure, and then it will be possible to appeal the acts within the framework of either the asylum procedure, either in the framework of the return procedure, if I understood well the system. In terms of goals, is that screening regulation or not a way of forcing frontline member states to do the screening? Because what has very often been said against southern member states is that they let the persons pass and they, for instance, do not put fingerprints in Eurodac. Is the screening, is one of the aim of the screening regulation also to find a solution to that issue?
Yes, indeed, Philippe. It is, the intention is to oblige the member states of entry, which is in essence mainly the frontline member states, Greece, Italy, Malta, to carry out the screening at their external borders, to also do the fingerprinting in Eurodac, and not to let the people simply abscond and possibly undertake secondary movements to Germany or Sweden. So indeed, the main aim is this common discipline, which, however, will then go hand in hand with the proposed solidarity. So the aim is not that Greece and Italy will remain stuck with all the migrants who are screened at their borders, but that it should go hand in hand with a binding solidarity with other states, like in essence the northern member states, then being willing to take up a part of the burden. And therefore also in the negotiations now, member states have a tendency of closely linking these two proposals. So they, particularly the frontline member states, say for very understandable and valid reasons, we only want to have this strict discipline if at the same time we also have measures of binding solidarity.
On that point, regarding the funding of the screening procedure, if I understood well, it is said that it will cost around 500 million euros for the first period. I don't remember how many years. But then I'm not sure to understand that. Does it mean that actually the funding of the screening procedure is entirely done by the European Union, and that member states will have maybe some costs, but extremely limited costs? Because this would be a change, because normally EU law is implemented for the moment by member states on the basis of European legislation, but then logically, if implementation is done by member states, the funding should also come from member states. Is it the reverse regarding the screening regulation?
Well, no, we don't really change the system how European law and the funds are working. We're not proposing this. So in essence, as you say, of course, Greece and Italy, they are in charge of implementing this regulation, should it ever be adopted. But what we can do at the European level is to use the financial instruments which we have, these financial instruments which are based on the idea of solidarity, that, you know, each EU member state is paying into a pot of money, and those who are most affected get the money in accordance to the degree to which they are affected. I mean, it's the way the external border fund is working, it's the way how the integration fund is working, the way how the asylum funds are working. It's always everybody pays into it, and then based on the degree to which member states are affected, the length of the external border, the number of third country nationals who have to be integrated, or the number of persons who have to be screened, they get money out of the fund. And that's the way we have also thought about the implementation of the screening regulations. So, and we made commitments also from EU side stating that to the extent possible under these new financial instruments, the costs related to screening will be co-financed or fully financed with the EU funds. This is the sort of the way how this would legally work. Which means concretely that member states may, of course, have certain obligations, but the majority of the costs would normally then be taken over by these union funds.
So this is actually an element of financial solidarity that you have in the screening regulation, and that completes the element of solidarity that you have in the asylum management regulation, with nevertheless, I deduce from what you say, a kind of evolution, because most of the cost would be covered by EU money, which is normally not the case. In general, most of the costs are bared by member states. So I understand nevertheless that there might be here a kind of evolution of the system, which is very, I think, interesting in terms of financial solidarity and the overall debate about who is implementing EU legislation. You know that there is a debate about the role of agencies that start to implement with member states EU legislation. So there the EU is entering the area of implementation. I noticed that here the EU is entering also part of the area of implementation, which is funding. That's not new as such, but nevertheless, what is new is that a big portion of the costs are funded by the European Union. So if we go back to what's happening at the border, you said that the objective is to send people either to asylum procedure, either to return procedure, but also to identify vulnerable persons, meaning that's not always very clear what is a vulnerable person. I would say a person having special needs that should be then covered by special reception conditions or special procedural guarantees. But if you take the practical case, for instance, of a minor, if you have a doubt about the age of a minor, which can often be the case when the person is supposedly around 17 years old. Is the person still a minor, below 18, or is the person already 18? It's quite difficult to say that. How can you do that at the border? What is going to be done about a person when there is a doubt about the age? And then another example would be about victims of torture or victims of trafficking. It is not written on their face that they have been victims of torture or trafficking. And you might not get the answer, a clear-cut answer of those persons in those circumstances at the border about the fact that they have been trafficked or tortured, because They need to be in confidence, and they need to be given time to say those things. So how do you see this happening at the border in a short period of time, 5 days, by the personnel, but mainly, if I understand, border guards who are not necessarily trained to detect torture or trafficking?
To start with, on the authorities who will carry out the screening, there we have Article 6, Paragraph 7, which makes sure that there should always be qualified medical staff carrying out particularly the health checks and the vulnerability assessment. Also, national child protection authorities, anti-trafficking specialists should be involved in the screening. So the idea is not to leave it simply to border guards, but when it comes to the specific vulnerability assessment and medical checks, to have specialists there. Of course, the maximum period of 3 days or 5 days is very short. And some things like an age assessment, if you need to make x-rays or more detailed medical examinations, it will take probably 2 weeks. So in certain cases, screening cannot be completed during these first 5 days, and there we have provisions in the proposal saying that in case, for instance, it's not clear whether this person is 17 or 18 years old, simply this fact shall be stated in the debriefing report, and then it will be to the subsequent procedure, to the asylum procedure colleagues or the return procedure colleagues, to continue the age assessment. So the idea is that whatever can be finished during these first 3 or 5 days should be finished. What is impossible to finish shall be continued in the subsequent procedures. Again, with this concept of seamless procedure.
Okay, so then you have a minor who is identified or not as a minor. If he applies for asylum, he is then channeled to the asylum procedure. If it is confirmed that he's a minor, he will then benefit from the specific guarantees provided by the Asylum Procedures Directive. If he doesn't apply for asylum, then he's channeled to the return procedure, and then he will benefit from the specific provisions on return of minors that you have in that directive. That's correct?
Indeed, that's correct.
Thank you very much. Now, during those 5 days or extended period of 5 days, 2 weeks, is there not a risk that you create a kind of legal limbo? Because what will be the status of those persons? Normally the idea is if you arrive and you apply for asylum, you become immediately an asylum seeker. Here during this 5 days period, it seems that the possibility to apply for asylum, or at least the consequence to be drawn from an asylum application, is delayed to a period of 5 days. So is there no legal limbo? And then what will be, for instance, the reception conditions for those persons during those 5 days?
This legal limbo point was also very high on the first, tide of criticism against the proposal. That we from the Commission, we were accused of really having created sort of a legal limbo within which there would be no legal safeguards, possibly not even this persons would not even be subject to the national legislation, because there's this mentioning of the non-entry fiction, so that these migrants would be considered not having entered, and some doubted what it meant and whether there would, EU legislation would not apply at all. So indeed, there was a need for clarification, and what we now constantly say, and I think that is now in the meantime broadly accepted, including by colleagues from the European Parliament, that of course anyone who is physically present on EU territory falls under the scope of EU legislation. This Article 4 of the proposal, which says that the person shall not be authorized to enter, this so-called non-entry fiction, is only set up in order to make sure that they are under migration law rules not considered of having legally entered. For the rest, these persons are on Greek, Italian, Maltese, Austrian territory, and Greek, Italian, Maltese law applies. We cannot through a proposal somehow undermine the applicability of national law, EU law, fundamental rights on member state territory. It would be impossible. So what is clear, whenever these migrants have managed to reach physically EU territory, EU law will apply. The question is, however, as you rightly put forward, what will, for instance, be on day 2 after arrival? An asylum seeker is in screening, he has applied for asylum. Will the Reception Conditions Directive apply, yes or not? Under which conditions can detention be applied? Will it already be the rules on detention foreseen in the asylum acquis, or will it be national law? Same goes for return. If you're an irregular migrant, on day 3 of screening, it's clear you're an irregular migrant, you have not applied for asylum. Would the detention-related provisions of the Return Directive already apply, or would the provisions of the screening regulation and national law apply? This was not 100% clear, I must confess myself, in the Commission's proposal. So very soon in the negotiations in the Council working group, it turned out that we really need to have clarified this very exactly, the scope. For the different categories, what are the rules applicable during these first 5 days? And the way forward, you find some indications in the APR, Asylum Procedures Regulation proposal, which you will hear about in the afternoon. The idea here is that for those who apply for asylum at the border crossing points, who really play with the rules and nevertheless fall in the screening context because the checks were not carried out yet, the asylum acquis and all the safeguards would start from day 0, so immediately, whilst for those who irregularly crossed the borders or those who were searched and rescued in an attempt to enter irregularly, for those the reception conditions under the Asylum Directive and also the Returns Directive would only apply after the end of screening. This being said, if we want this to be clear, it needs to go hand in hand with a corresponding change to the Reception Conditions Directive. You know, the Reception Conditions Directive is also currently open, and if we want to exclude from its scope certain categories of asylum seekers during the first days, this needs to be put crystal clear in the scope of the Reception Conditions Directive. Because with the legal finesse, with the screening regulation, which is a Schengen Act, we cannot determine the scope of application of an Asylum Act. The Reception Conditions Directive is an Asylum Act. And if we don't want the Reception Conditions Directive during the first day to apply to asylum seekers who have entered irregularly, we need to put this in the Reception Conditions Directive itself. It's different for the Return Directive, since the Return Directive is also a Schengen Act, screening regulation is a Schengen Act, so the scope of the Return Directive can be determined in the screening regulation, we can put it. I know it's very tricky and complicated, but somehow it's the result of this also variable geometry you have heard about already, I'm sure, last week, and these different member states participating at different instruments. I hope this was somehow clear.
Yes, indeed, this is one of the issues giving a headache to people, and I imagine also negotiators, the fact that sometimes you see that in one instrument there is a mix of Schengen provisions and non-Schengen provisions. So the issue is, can you do this? Because that would be a bit strange. For instance, if you mix Schengen and non-Schengen provisions, how will the vote be organized in Council? Because the member states do not have, some may vote on Schengen, some may not vote on non-Schengen. So that's a quite complex issue. And this came up also in the European Parliament, because the different elements of the pact had already been distributed to rapporteurs. And behind the rapporteurs, you have, of course, a political group. And then the issue came up, it was raised by the legal service of the Council, that you cannot mix up non-Schengen and Schengen provision in one single instrument. Then the idea was maybe to cut the instruments, to have Schengen on the one hand, non-Schengen on the other hand. But then this had a consequence for the rapporteurs. That were then seeing, well, their report either becoming bigger, either becoming smaller, if I understand well the issue. But how can you introduce into the Reception Conditions Directive a provision about reception conditions at the border, which is normally then, as you said, part of the Schengen acquis, while the reception condition is not part of the Schengen acquis.
The Schengen acquis relates to border controls and can be extended, to the screening checks and the first days. This is Schengen acquis. However, as soon as someone applies for international protection, you fall in the scope of the Reception Conditions Directive, and you are in the asylum acquis. It can be that on this person then, border checks can be continued, while at the same time this person already benefits from the benefits of the Reception Conditions Directive. Therefore, it can frequently be that you are at the same time subject of two different legal regimes. It's also as an EU citizen, when you enter the EU through an external border, you're a beneficiary of free movement, Directive 2004/38. At the same time, you are subject to border checks according to the Schengen Borders Code. So this is nothing strange in our legal system, that a person is at the same time, in the same situation, subject of different legal rights and obligations. But what we need to avoid, that there are contrary statements. For instance, that for an asylum seeker who is in screening on the first day, the screening regulation says more or less the person shall be kept in a facility or deprivation of liberty, whilst in the Reception Conditions Directive, which would be applicable in parallel, says detention shall be the exception and only in a case-by-case assessment. So if we have inconsistencies between the legal regimes which would be applicable, we need to take care that there is no contradiction. And avoiding a contradiction could either mean that the screening regulation clearly says that for asylum seekers from day zero, the issue of detention, for instance, is not regulated in screening. It's left up to asylum or return. Or the asylum and the return rules say that as regards the first days, possible detention and deprivation of liberty is still governed by the rules relating to borders. So the instruments, they need to fit together.
So we are not going to continue that discussion in order not to bother you with those very technical elements, but you can see that another quality of Fabian Lutz is to be, on the one hand, an excellent lawyer, but on the other hand, somebody also extremely pragmatic, who tries and very often succeeds in explaining clearly the most complicated problems. And this, of course, helps during negotiations, because you imagine that in Council you have 27 delegations of member states. If you enter into complex discussions where people get lost, this will not help and delay the procedure for the adoption of the act. So I think that once again you are the right person at the right place for the screening regulation. Now, just to touch upon that issue, is detention not de facto a necessity? Because you want, of course, the persons during the screening, you want to avoid that they disappear, because otherwise you don't reach the goal of the screening, which is to control everybody. So, and then as you already mentioned, that would be then systematic detention of everybody, so that's already a change de facto. And then you have, again, a very complex legal issue. Is that detention covered by the Reception Conditions Directive? That could be the case for persons applying for asylum, but not before they apply for asylum. And what then about the case of persons who do not apply for asylum before the issuing of a return decision? You cannot apply return detention, because detention for the purpose of return, by definition, needs a return decision. So what about that? Another kind of complex issue, and a hot issue, because of course NGOs have already underlined that systematic detention at the border would not be a good element, and that it is part of the ideology of Fortress Europe, and so on and so on.
The screening proposal itself remains relatively silent on detention. So what we have is Article 4. I read it out. Article 4.1 saying during the screening the persons referred to in Article 3, so the screened persons, shall not be authorized to enter the territory of the member states. That's all. Shall not be authorized to enter the territory of the member states. It's an obligation on member states telling Greece, Italy, you must ensure that the screened persons are not authorized to enter. How can you do that? The text is further on silent. In the recitals, however, it is mentioned that member states may refer to detention if this is needed. And also in Article 7 of the proposal, which is on monitoring the respect for fundamental rights in the context of screening, you have then a reference that's saying that when member states apply detention, that the monitoring should also monitor the use of this detention. So behind the lines of this Article 4, you indeed see this obligation of member states to make sure that the persons do not enter. And in most cases, probably the only way of making sure that persons do not enter is to put them in closed facility. We always underline from the Commission said respect of proportionality and give preference to more lenient measures if possible. So possibly on an island you can have an open facility because anyhow the persons cannot escape from the island and enter the rest of the territory. Whilst in the mainland, I mean, if you're in Vienna or in Berlin and being screened, then probably you will need to place the person in a location which is a detention facility. So this is what the proposal says. What the fundamental rights say, that's also important to underline, in relation to detention, you know that the European Convention of Human Rights distinguishes between the use of detention in view of preventing an irregular entry and in view of returning or removing a person. In the first case, in view of preventing irregular entry, the case law of the Strasbourg Court is relatively generous, and it even accepts a more or less systematic detention as compatible with fundamental rights, provided it's not arbitrary. So the Strasbourg Court does not really require individual case-by-case assessment, but the assessment is that it should not be arbitrary. And being not arbitrary, there are again criteria, human and dignified treatment, it's a decent detention condition, so all this must be in place, clear legal rules setting out the regime, but in principle, at least under fundamental rights, under the European Convention of Human Rights, member states could apply during the first days this form of placing screened persons in a closed facility. This being said, also in our recitals, we then refer to the fact that there should nevertheless be an individual case-by-case assessment. So this is somehow also left open, and I'm sure during the negotiations, particularly with the Parliament, this will be a hot potato, and we will certainly come back to it frequently in the discussions.
So if we try to understand the system, it means that we had already two main forms of detention, return detention and asylum detention. Here we would have something like screening detention that would be not regulated by the return directive or the reception conditions directive, if I understand well, but by, you say, the case law of the European Court of Human Rights in the absence of detailed provisions in the screening regulation.
Indeed, it would be national law under the control of case law of the European Court of Human Rights and also the Charter of Fundamental Rights. Because if member states are implementing, if Germany is implementing Article 4.1 of the screening regulation, it is acting in compliance with union law. It needs to respect the Charter. So, and when explaining this to member states, again, and also to the Parliament, we say normally it's nothing really revolutionary or new. We already have systems like this in all member states already now, for instance, in the transit zones of international airports. If you come from Ecuador to Brussels and you're stopped at Brussels airport, at Zaventem airport, and the border guards find out that you are not entitled to enter, then you will be refused entry probably, and you will be sent back to South America. But if the next flight only goes in 2 days, in the meantime, during the 2 days, you will be placed in a detention facility in the transit zone of Zaventem Airport, and this is covered currently by Belgium national law, incompatibility with fundamental rights. So, and member states would continue more or less to apply these existing national regimes for those kept in detention under the screening regulation. This is the way how we as a Commission currently explain this Article 4.
But except that in the case of persons put in detention in the transit area, you have a return decision. so that the return directive applies, if I understand well.
Not necessarily. In many transit areas, if you refuse entry in Belgium, for instance, you don't get a return decision. You simply get a refusal of entry, and you're told you take the next plane. You can sleep for 2 days now in this facility, and afterwards you take the plane. And it's only if the person then actively refuses to board the plane that probably the Belgians would have to adopt a return decision and a removal order and to physically enforce it. But if the person voluntarily boards the plane and flies back, there is no return decision.
And I remember that you have in the return directive a provision allowing to make an exceptions for decisions taken at the border. Member states can exclude that from the scope of the return directive.
Indeed, this is the current status quo, that we have Article 2.2a of the return directive, which says member states are not obliged to apply the full procedural safeguards of the return directive for those migrants who are apprehended in connection with the irregular crossing of the external borders. But they must be really caught in the act. So when you catch someone swimming through the Evros River, then you can use this Article 2.2a of the Returns Directive. If you apprehend an irregular migrant in the streets of Budapest, 1 week after the person has entered, the person falls fully in the scope of the Return Directive, contrary to what the Hungarian delegates may wish. And you need to respect the full safeguards. But this indeed, I mean, it's an issue which is also now being discussed, again, in the screening context. And many member states, not only Hungary, would maybe like to use the screening regulation now to broaden a bit this scope of application of the border exception, the return directive, and also apply it to those who are apprehended in the territory without having fulfilled the entry checks.
Thanks a lot for this explanation. A very last questions before going to the audience for comments, remarks, and questions. What do you answer to some people say that actually this screening regulation blurs the distinction between irregular migrants and asylum seekers because they are all put in the same screening procedure during this 5 days or 2 weeks period?
It is not blurring at all. I mean, again, with legal precision, if you look, starting point again, Schengen Borders Code, Article 13, border surveillance, an obligation on member states that irregular crossing of the borders is prevented. Also, an asylum seeker who is swimming through the Evros River or who takes a boat and is being smuggled, even if he's an asylum seeker, nevertheless has irregularly entered. So both irregular migrants and asylum seekers who come irregular, they are irregular entrants. And that's the common starting point of both categories. And here it's legitimate to make sure that on both categories these checks, security, identity, health checks are carried out, also vulnerability assessment, and then to channel the persons to the right procedures, either being an asylum procedure or a return procedure. But the starting point of the application is this irregular entry, which per se should be prevented.
Yes, I see, and this is actually then a kind of reference to Article 31 of the Geneva Convention, which says that asylum seekers cannot be punished for their irregular entry, but nevertheless, they enter irregularly if they do not have the documents. Yes. So, I'm not going to prolong this discussion. Why have we organized this? Well, because we wanted to give you a taste of the kind of discussions that the Commission will have with member states in Council and with members of the European Parliament and, of course, mainly the rapporteurs and shadow rapporteurs, so that you see how technical these discussions are, but nevertheless, behind these technical discussions, you have the issue of human rights. And you need then to understand which texts do apply. And you have the Charter also that can apply when member states implement EU law. And actually the screening regulation is EU law. Then you can say that during the screening procedure, the Charter does apply. So it's technical, but at the same time, it has consequences for human rights, and at the end, of course, it is also political. But you see that it's a mixture of technical and political discussions that you then have in the institutions between the two co-legislators. I propose now that we turn to the audience for comments or questions, remarks, and let us, as always, start with the persons following us online. We do not forget you. Despite you are far away, you are virtually with us. And please, our technician team, could you tell us if we have persons online asking for the floor?
Actually, there are no questions so far.
Not at all.
Not at all from the online participants.
Okay. Then let's look at the audience, and if you could please circulate the microphone. And I see already one question there. Another, I will put my glasses to see who is asking. One there, one there, one there, one there. Oh, 5 questions already. Okay, let's collect these 5 questions, 4 questions. Because Marco is there, these 4 questions before giving back the floor for answers to Fabian.
Okay. Thank you very much for this very interesting discussion. I have 2 questions. The first one, which is exactly the role of EASO and Frontex related to the screening procedure? So, because I think that the Article 6 in this is very vague, and about the collaboration and which type of collaboration and cooperation exist or could exist between member states and agencies. And if you can explain practically which will be the pattern of collaboration of member states and agencies. And a second question is from a very broad political standpoint. Do you think that this proposal could exacerbate the pressure on southern member states on the border in the event of large migration flows? Thank you.
Okay, that's one first question. Let's collect other ones. We have 2 here.
Hello, my name is Juan. Thank you very much for this really interesting debate. I have a question regarding detention, because you said that under the ECHR, exactly the court gives a broad leeway to the states. They don't have to do an individual assessment. However, under Article 52 of the Charter, it says that limitations to fundamental rights have to be necessary, and this means that states have to look for alternatives to detention in the case of the right to liberty. So how could you justify then the automatic detention in the screening regulation? Isn't there an obligation to look for alternatives for each person? Thank you very much.
Wow.
Hi again. Thank you for this really interesting debate. I have doubts in the compatibility between this screening assessment, because if I got you right, you said that this is non-binding, but then my question is if it can be used as a ratione or as a base for the individual member state administrative person or border guard taking the procedure. And the second question is, and also if I got it right from the proposal, is that border procedure and asylum procedure can be solved in the same act, in border procedure, something like that. And how does it deal with this variable geometry? Because a return comes from Schengen acquis and asylum comes from the migration acquis. So how those 2 aspects deal? Thank you.
So let's maybe take those first 3 questions because they are quite complex and technical. Fabian, I leave you the floor. I'm happy that I do not have to answer them. So I give you the floor.
Well, the reply is clear on all except for detention, I would say. So the first question is the role of the agencies. We have foreseen this in Article 6, paragraph 7, 3rd subparagraph. The competent member state authorities may be assisted or supported in the performance of the screening by experts or liaison officers and teams deployed by Frontex and EASO within the limits of their mandate. So, which means that if member states wish, they can ask for support by these agencies, by the specialists or the teams, and they can be supported. That's all what we say here. We don't specify in some more detail what exactly should be the role. We're just referring to the mandates, respectively, of these agencies. And if you want to have an idea of how this could work in practice, I think the currently operated hotspots, which we have, and where we also have involvement of these agencies, can be sort of a good indication of what the concrete tasks would there be. Linguistic skills, help in assessments, also help in administrative issues, this check. So based particularly on the skills of which these specialists from the agencies have. Your second point, whether the screening regulation would exacerbate the pressure on the frontline member states. Indeed, this is true. As I said in the beginning, if we have a stricter obligation really to carry out the check on each irregular migrant or saved and rescued person, this exacerbates the pressure on those states who have the highest inflow of irregular migrants, because they must comply with all the obligations, and they are also obliged then to keep them within their territory, possibly also for the subsequent asylum and return border procedure. And for that reason, as I said, for the frontline member states, for the current frontline member states, it's very important to have the screening adopted as a package together with solidarity with the AMMR, because they need to have certainty that if they take over the obligations resulting from screening, they also are relieved somehow from part of the burden through solidarity, through binding solidarity. On detention, I cannot really give you a very detailed reply. Indeed, what we have is this differentiation in the Strasbourg case law, saying that in preventing, making sure that irregular entry is prevented, member states have more liberty than in the field of return and removal, because the court Strasbourg court makes a difference between those who are not yet fully in and those who are in and must be removed. And then, as you rightly say, of course, in the application of union law, also the charter is applicable, and automatic detention, indeed, I would agree with you, it cannot be applied. So there should be always a case-by-case assessment, which, however, maybe could be also case-by-case assessment limited to specific case constellations. So not necessarily during the first days that you consider each individual person, but groups of persons in specific places, in specific circumstances. But indeed, I agree with you, there is scope for really further elaborating on this, and also for the legislator to find, on the one hand, fundamental rights compatible, but on the other hand, also practically feasible solutions. Because the main idea, and this is, I think, shared by everybody, is we must make sure that the persons don't simply disappear. This is really, it's a legitimate consideration. The next question then was, what's the legal nature of this assessment, which we have, if you look into the proposal, it's currently called Article 13, the debriefing form, where all this information is listed. Is it binding? Is it not binding? What we say, also in the negotiations now with Council and Parliament, we strongly defend the line, it is non-binding. It's just a preliminary fact-finding, evidence collection exercise. At the very beginning, it's easier to collect evidence, like when the police is arriving freshly at the place where a crime was committed. It's also, the earlier you come there, the easier it is to get reliable evidence. And then what to do with this evidence, that's really up for the authorities in charge of the subsequent procedure, be it asylum or return or refusal of entry. If there would be a binding nature of this assessment, so if the screening authorities could say, we know that you come from that country and therefore you must go into the asylum border procedure and not the full asylum procedure, then it would be a legally binding act with legal consequences, and then we would need to foresee a right to appeal. Otherwise, the whole proposal would be contrary to the Charter. So the only way of sort of interpreting this proposal also in line with the Charter is to say it is legally not binding. It's just fact-finding exercise. And again, the example I'm using is always the example with the existing rules under the Schengen Borders Code. Also here under the Schengen Borders Code, we have this what we call the extended second line check. So when border guards have a doubt on a migrant, they ask him to the back room, they conduct a longer interview and collect all the information they can get from this person. They produce a report which then goes to the return or asylum or other authorities. This is also something which already exists in the Schengen field and is not labeled as a formal decision. And your last question, whether border and asylum procedures would be conducted in one and the same procedure? No, this is not the case. So screening is Schengen acquis. Screening is conducted during the first days, and it ends with the establishment of this debriefing form, of this document where the preliminary evidence is then passed on to return asylum procedures. And only from that moment, the asylum procedure phases in. And this is then done by the asylum authorities. Or if there is no application, it would then be a return procedure or a refusal of entry, and then it would be up to these authorities. But we don't mix. It could not be done also for legal reasons. Thank you.
And the Asylum Procedures Directive is non-Schengen relevant, while the Return Directive is.
Yeah.
Okay. Thanks a lot for these answers. There were other questions on the right side, on my right side.
All right, good morning. So I have a lot of questions in mind, but I'll try to focus on 2 points. So first of all, a practical question. So you mentioned like how screening procedures represent a fact-checking. So could you please do like a practical exercise and explain us how do you fact-check if a person represents a threat to the public order? So how this screening would be practically conducted, and if you don't think, what do you think about the risk of discretionary, the discretionary power of the agents that will conduct this exercise? Whereas the second question is more, I think, like a political one. So after this hour of discussion and the legal chat and the way also professor has like challenged a bit like your statement, to be honest, I don't feel very convinced by this legal framework that you have presented, and I have the feeling that at the level of the Commission, there has been this legal exercise to normalize and justify a political debate, rather than providing a legal framework that would protect fundamental rights. So would you be able to contradict me? I hope so. Thanks.
There was another one. Yes. And then we will end up with that question.
Thank you very much. I think that my question has been partly answered in the first block of questions, but it was more linked to the fact that this screening regulation is linked to its compulsory. So all states should comply with these new norms. But if I remember correctly, when it comes to the solidarity branch of the new pact, this is based on the principle of flexibility. So my question was, how can we establish a balance between the pressure that all these states are gonna have, because they are it is compulsory for them to check on these irregular migrants and keep control on them and prevent them from exiting their borders, and the fact that in order to decompress a bit the situation in these countries, this second part is based on flexibility. How can we establish a balance between these both aspects? Thank you.
And Professor, I think there are also questions online.
Precisely to ask this, let's collect 1 or 2 questions online from the persons following us from abroad.
Yeah, we have 3 persons who are waiting. So I'll give the floor to Leva, the first one, and then it's going to be Justina and Emily. So in right order.
So can we see Eva? If Eva has opened her camera, of course.
Yes, it's open. We'll just to see with the technician. Thank you.
Hello, Eva.
We cannot hear you, Eva.
You may have to open your microphone. No, we still cannot hear you. Where is the problem? Here or with Eva?
Maybe, Leva, can you write your question and I can read it because we cannot hear you.
Yes, that's a good idea. Eva, can you
Please
type?
go on if you want with other questions.
Okay,
Excellent.
perfect. We can hear you.
There you are.
You can hear me now.
Yes.
Okay, thank you very much for solving this. So thank you very much again to the presenter for a very interesting presentation. I have a question which is related to the impact assessment process of EU law when it has been drafted. More precisely about that part of impact assessment procedure which requires to assess administrative costs and compliance costs of a new legislation. So as we are talking about basically adding a new element of administrative procedure, I would like to know if there is any ex-ante assessment at this stage, and if there is not, will there be one, and what is your expectations about how you are going to get data on possible administrative costs in member states regarding the, let's say, different situations in them in this regard. Thank you very much.
Thank you for this very precise question. So we have two other persons online normally.
Yes. So
Emily?
Justina, you can ask your question.
Good morning, everyone. Can you confirm that you can hear me?
Yes.
Great. Thank you very much, Mr. Lutz, for a great presentation. My question is on data and information protection, and we have recently seen personal data being improperly collected and shared. And in mind, I have an example of the UN and the personal information of the Rohingya refugees. How will the data and information provided by third country nationals be stored, and who will be shared it with to avoid any potential breach? Thank you very much for your answer.
Thank you. And then the last question.
Yes, it's going to be Emily.
Hello, I have a very short question with regard to, basically, I understand that the debriefing form is not legally binding, but when you detain a person, typically you would issue a detention order. And I understand often at borders, a detention order isn't issued due to the short period in which they're in a transit zone. But from my understanding of the screening regulation, people may be detained for longer than they are typically now, say in an airport under the Schengen Borders Code. So I wonder if you can talk a bit more about whether there will be a detention order, and if not, why that wouldn't happen. Thank you.
So thanks a lot for all these questions. I think that you have enough on your plate, dear Fabian. And you see that our participants are quite good lawyers as well. They have extremely precise questions.
Yes, it's mainly thanks to your splendid summer university that you have so good participants, dear Philip. The security checks was the first. How to make sure it's not arbitrary, these checks. I mean, we have detailed rules in Article 11 and 12. It's not that a border guard can simply say, you look like a gangster and you are a security risk, but we have rules here on which objects in the possession and checks can be carried out, biometric identifiers to be taken, then certain databases to be checked, namely the SIS, the Schengen Information System, the Visa Information System, then in the future, Entry-Exit System and ETIAS, and Europol databases and ECRIS, so this European system with where you find data about criminals, including third country criminals and arrest warrants. So you have, in principle, the main source for doing the security checks is doing checks against the relevant databases based on the biometric identifiers of the apprehended persons. In the same way as it's already done now in the entry checks under the Schengen Borders Code. I mean, so you see, it's really complementary that these security checks, we already have them now in the Schengen Borders Code, and we want to at least have the same level for those who enter irregularly, and therefore we foresee these checks against the databases in Article 11 and 12 of the proposal. the second question from your side, I'm not sure whether I fully got it. You were asking, I mean, more this political question that in how far we from the Commission consider that we protect fundamental rights in a right way. Protection of fundamental rights is not an objective per se. The objective of screening was also to manage migration, to make sure that those who irregularly enter the border in infringement of Schengen Borders Control are stopped, are properly checked, made sure that there is no security risk, identification is done, in order to have a well-managed broader migration system, channeling them in streamlined way into the asylum or in return procedures. So the objective is really also migration management, but doing this migration management in a way which is fundamental rights compatible. So it's both are sort of two different sides of one medal. The medal is we need to do a credible, comprehensive migration management, and for doing so we need, on the one hand, if you want, repressive measures. On the other hand, we need safeguards, making sure that fundamental rights are prospective. So it's not one against the other, but it's more how we can reconcile it in a convincing and reasonable way. And I believe that with the screening proposal, the Commission has done a proper job, and we have managed to find a good balance. That's my personal assessment, but of course I know each one has different levels of assessment and puts different priorities. But this is then more a question also of again, personal statements. The next point on this flex was the point that on the one hand, the AMMR is relatively flexible in assuring solidarity, while screening provides for a straightforward obligation on frontline member states. How can this be brought together? I think it's a very relevant and good question, and if you find a very good answer to this, you will be the hero of the next European Council. This is exactly what the current debate on the Migration Pact is about. To what extent can member states agree on a flexible solidarity which is still binding enough to reassure frontline member states that they will not remain stuck with all the migrants? This is in essence the key for finding a solution. And that's what's going on now at the field of negotiations, and we'll have to see if this challenge can be overcome or not. I think there is not more that I can reply on that. Turning now to the online questions. A very concrete one, impact assessment and the financial and administrative costs. In fact, there is a financial statement which was annexed to our proposal. So the proposal, I can give you the reference number, it's the COM 2020-612, and annexed to it you find a financial statement which assessed the financial costs of the screening, if implemented correctly by member states over the next 7 years, finding out that it will cost several hundred million euro, 400, 500, but of course with all the uncertainties we have here, because we don't know, I mean, it all depends on the number of irregular migrants. It's a different, if there are 100,000 irregular migrants or 900,000, and all this will depend on global development, so it's very hard to give an assessment. And next to this assessment done by the Commission, the European Parliament is currently also doing its own impact assessment for the Commission proposals, because the European Parliament felt that the Commission had not properly studied the impact, not done a proper impact assessment. So the Parliament is now producing its own impact assessment, which will also certainly have information on these financial aspects. The next question was on data protection. How do we ensure that data protection are not unduly infringed, particularly where it's very sensitive in the case of refugees, so that the home authorities should never learn that someone is staying in the EU or through checks learn about this fact, because this can really be life-threatening for certain categories of refugees. We know there are manifold safeguards in the text. I think if you look into the proposal itself, more than 50% of the text, particularly all these Articles 15, 16, 17, which deal with access to the different databases, specify in detail which authority will have access to which category of data and which provisions will apply in respect to data erasure. So that next to the general data protection regime, which applies anyhow, the proposal contains a lot of specific provisions which are focused on that, but I spare you the details. They are so complicated that I think only very few experts really can understand them, particularly in the new databases, entry-exit system, ETIAS, and so on. But I can reassure you the safeguards are there. And the last point, will there be a need for a detention order if you keep someone for 5 days in a facility at the external border? As I said in the beginning, the proposal remains silent on that. The proposal creates an obligation on member states to make sure that the migrants do not abscond, do not enter the territory. How this is done, it's left to member states. So member states may continue their current national practices. I know, for instance, in Germany, you can have a detention in the airport transit zones for going up to, I think, 30 days, or some a very high number of days, going far beyond the time frame of the screening authorities, not even subject to judicial control. It's administrative detention. So when member states ask us now in the negotiations, how should we do it? Our reply is always, continue doing what you currently do in accordance with your national law, which, as we are convinced, should also be compatible with the Charter and fundamental rights. So continue national practices. In some member states, there may be a detention order already on the first days. Others may only give it on day 5 or day 10. This is up to national law. We have deliberately, from the Commission side, refrained from setting out a new detailed detention regime, which, as I say, would be the 3rd detention regime next to the element return, in this proposal, since we know how tricky and how complicated and how political it is. Thank you.
Thanks a lot, Fabian. So indeed, there will be an impact assessment done by the European Parliament. We may have the results quite soon. It is done by the CEPS, which is a think tank in Brussels, coordinating this impact assessment, and it will be extremely technical and legal, because they have been asked by the Parliament to see the impact of each instrument and almost each provision of those instruments. Actually, Odysseus could have applied for doing this impact assessment, but when I see the complexity of the issue, maybe I'm happy that we didn't apply for that. And then about detention, that's a very interesting point. It seems that there is maybe what some lawyers call a kind of black hole that has to be filled by national law, but that maybe raises questions in terms of human rights protection. In particular, if you say that in Germany there is no judicial control on that short period of detention, that might be a problem. But it's true that we have that already, that kind of question. For instance, even the return directive, when the police arrests, apprehends somebody, and then before a detention order is taken, the police needs to check if that person is staying legally or illegally. There is a kind of period also which is not regulated by the return directive. This has been confirmed by the Court of Justice. So this is then under under national law. But of course, these are very short periods that probably are covered implicitly or explicitly by national provisions. So let's ask if there are one or another more question or comment, either online, either in the room. Somebody online?
No question online.
Okay, then let's take one or two last questions. And here we have one question of Juan.
So just a follow-up question on detention. So is it possible that if detention is regulated under national law, that then the EU Charter does not apply? Because could it be argued that the member state is not applying EU law and therefore the Charter doesn't apply? And then another question on the asylum. I didn't quite understand, if an asylum arrives irregularly, then in principle the reception condition directive would not apply during these 5 days? Or yes, this I didn't understand.
Thank you very much for that question. There is another one there.
Thank you. I have actually two questions. One is maybe if you could tell us a bit more about to what extent did you draw lessons from the practice in the hotspots when drafting the screening regulation. I'm thinking about, for example, what's happening in Greece with the EU-Turkey deal, where you have like first a screening and then supposedly a vulnerability assessment. And we see that in practice when there are like a lot of people arriving at the same time, actually the vulnerability assessment cannot be processed within a few days, and it ends up with people not being screened in terms of vulnerability for a really long period of time. So maybe what this practice can tell us about maybe some challenges for the screening implementation of the screening regulation. And the second one is about what you just said about judicial, I mean, how we can challenge detention within the screening regulation, and that it can be for member states to apply their national legislation. Don't you fear that there might be differences of treatment about people between like those being screened in Hungary, for example, and those being screened in Spain, Greece? Like, don't this, like leaving it for member states to decide how they deal with detention, won't that in practice cause some differences of treatment in terms of human rights implications? Thank you.
Thank you very much. One very last question, if there is. No? Okay. Then Fabian, you have the floor.
The first point was whether the Charter would be applicable if member states under Article 4 comply with their obligation not to allow entry and therefore put migrants in detention under national law. Our view is that the Charter would be applicable since member states are acting in compliance with an obligation set up by union law. Probably some member states would contest this, and then it would have to go up to the European Court of Justice to decide, but our view would be that they are acting in compliance with an obligation under union law. The other question was on the scope of the Reception Conditions Directive. So let's now distinguish, as we said, the lawyers, the lege lata and the lege ferenda. The lege lata, as the law stands now, the Reception Conditions Directive is applicable from the date you apply for asylum. So from day zero. And however, in the screening proposal, if you read the recitals, there is this idea that the reception conditions should only start applying from the end of screening. If we want this to become reality, and that's what I said, is the lege ferenda, through a change of the text, which is anyhow currently open. We have an open change of the Reception Conditions Directive in the pipeline. There needs to be a change to Reception Conditions Directive saying that in case of this initial period for these specific categories of asylum applicant, Reception Conditions Directive would not be applicable. For as long as this is not decided, Reception Conditions Directive will apply as from day zero. This is the law as it stands now. Then your question on the inspiration drawn from the hotspots. Yes, I understand there was much inspiration indeed drawn from the hotspot, particularly on the needs, what needs to be checked, on the need for assistance by the agencies. And at the same time, there was also this choice made that for the screening, we want a very strict upper time limit. We don't want screening to drag on endlessly, member states saying, we need more time, no more resources, and the screening being taking 1 week, 2 weeks, 3 weeks, 2 months, because this would then be lead to this somehow the Morias and other centers, and this definitely should be avoided. So that's one of the core rules in the directive is this upper time limit, up to 5 days, and maybe in very exceptional circumstances, another 5 days, and that's it, not longer. And also the possibility of detaining under national law for screening purpose is also limited to that. And afterwards, you go either into a full return procedure with the safeguards or into an asylum procedure. So this is the idea behind. And on your point of this challenging these detention decisions under national law, whether this would not create a discrepancy of treatment in member states, the reply would be yes, because then in Germany the German rules would apply, which I cannot imagine against the Charter of Fundamental Rights, since the German constitutional courts have such a high level of fundamental rights protection, but we don't know. And in Hungary, Hungarian national law would be applicable, and in Austria, Austrian law on this initial detention would be applicable. The political choice which we made, that we don't want to regulate it in the screening regulation, has as an automatic consequence that these different national regimes would be applicable. This is true. Still with the protection of the European Charter of Fundamental Rights, which applies throughout, because it will be an application of union law, but the details will be regulated in member state law in differing provisions. This is true. The alternative would be to have a fully fledged EU screening detention regime, and there was the political decision of the Commission that the Commission does not want to propose it at that stage. Thank you a lot. Thanks a lot for the interest as well.
Thanks a lot, Fabian, for all these answers. So is this the nightmare of lawyers or the dream of lawyers? That's up to you to say. Your interest is very high. So I'm quite sure that in the future you will have the possibility to prepare papers, to draft papers and to publish articles about this screening regulation that will become a real regulation of interest for lawyers. I'm sorry that we were not a lot of persons this morning because it was a really interesting session, but okay, we have to take into consideration also the persons who are online. I'm nevertheless sorry, dear Fabian, that despite your very interesting speech, there were not so many people. Probably that the Italians are still drunk because of the football match, that the Belgians are absolutely desperate and do not want to enter in particular because it's raining, and that others are tired because they don't like football and they went doing some tourism here and there. One lesson that we have to draw is probably that the second Monday of the summer school you do not organize a debate because people are not, all people are not there. But really thanks a lot, Fabian, and good luck for those negotiations.